roundtable discussion with the legal professionals at the Michigan Creditors Bar Association. They're the legal representatives of small businesses and large all across Michigan who are trying to collect on debts based on credit they provided to consumers. You're going to hear from these professionals talk about why our entire economy is based on credit, and that if legitimate debts aren't handled properly and repaid in some fashion or settled, it negatively impacts not only the small businesses and the debtors involved, but it greatly impacts all consumers across the board because it impacts their ability to have good, affordable, ready access to credit for their own personal lives as well. I think, as everybody knows, the Justice for All Commission, started by the Michigan Supreme Court, but really powered by the operations of the Pew organization, have come out with several reports. Last year in September, they came out with a report specifically targeted on the debt collection part of their mission to increase the ability of regular citizens to access the courts. And after that report came out, it did not include a lot of things that the Michigan Creditors Bar Association felt would be natural things to include, that the courts administratively could undertake on their own right now, that would improve citizens' ability to access the courts, to communicate and talk to those they owe debts to, and come up with a solution that doesn't involve them having default judgments or having their wages garnished. So with that introduction, I'm going to introduce Mike Buckles, one of the government affairs officers for the MCBA. Mike, please go ahead.
Lisa and Ben, thank you. My name is Michael H.R. Buckles. I'm an attorney. I'm a consultant for the law firm of Buckles & Buckles, PLC. I've been practicing debt collection law for 48 years. I'm also the government affairs director for the Michigan Creditors Bar Association. What I'd like to do is share with you some points that will help us better communicate where we are and where we're going. The Michigan Creditors Bar Association has presented an 8-point plan to the Michigan Supreme Court to help consumers navigate debt collection lawsuits, avoid default judgments, and reduce caseloads by implementing technology and facilitating better communication with consumers. The MCBA plan will help Michigan families and our economy by modernizing the legal debt collection process. The plan will help consumers engage with creditors and resolve overdue debt with payments and settlements instead of being garnished. Let me repeat that. Instead of being garnished, our plan will help consumers engage with creditors and resolve overdue debt with payments and settlements. Debt collection sometimes gets a bad rap, but it's an essential part of Michigan's credit-based economy. Repayment of overdue debt protects and preserves credit for all families, as well as businesses and government. It's what makes our economy work for everyone. The Creditors Bar strongly supports the goals of access to justice. That goal was set by the Justice for All Commission established by the Supreme Court. And that project was funded by the Pew Charitable Trust and managed by the Supreme Court. That is why our plan proposes that the Michigan Supreme Court and the State Court Administrative Office act now to reduce the workload of the court clerks and simplify the legal process for consumers by implementing the reforms in our 8-point plan. So our plan supports the JFAC goals to simplify legal debt collection process for unrepresented consumers, to encourage communication, find resolution without the need to take default judgments and garnish. And that distinction is very important. We believe the JFAC report published last November was biased against legitimate debt collection and therefore too focused on default judgments and garnishment, instead of focusing on fixing systemic problems and avoiding default judgments that typically come before garnishment. So our plan is this. SCAO should implement statewide e-filing system in the district courts. Since 2016, SCAO has collected over $50 million in e-filing fees. But now, in 2023, less than 10% of Michigan courts have e-filing capability. This means about 90% of Michigan courts are unable to use e-filing technology to process their caseloads. MCBA helped draft and pass the e-filing law in 2016. And since then, our creditor clients have paid millions of dollars in filing fees for the past 7 years with little progress by the court administration. Number two, in our plan is that the Supreme Court can reduce default judgments by continuing to promote and maximize Zoom hearings for consumer debt cases. Remote hearings make it much easier for families to participate in court proceedings. They help parties communicate and reach a solution to pay overdue debt, so the case does not result in a default judgment. Number three, SCO should create and promote a state-sponsored one-stop website that would educate consumers about debt collection lawsuits and how to avoid default judgments and garnishment. The site would encourage consumers to communicate with creditors and their attorneys. And a link to this website could be included on all summonses, notice of hearings, and default judgment. Number four, the Supreme Court can empower consumers by creating a notice of rights form to be delivered to consumers with the court summons and default judgments. The form would include a link to that dedicated website I just referenced, and it would be on every court document delivered to a consumer defendant so they know what to do, how to do it, and when to do it. The Supreme Court can encourage consumers to communicate by requiring courts, not creditors' attorneys, to mail notices and default judgments to consumers. The current rule since 2019 requires the attorneys to mail these notices, but having the court's name on a return address of an envelope would encourage consumers to open mail, so they'll be more likely to appear for hearing dates, and they'll know about a judgment and its consequences. And in fact, if we could get the courts to modernize, they could even send text messages to remind consumers about hearing dates and times, just like our doctors and dentist appointments are sent to us with text messages. Number six, the Supreme Court can implement MCBA's service of process standards to encourage consumers, to encourage the consumers are properly served with debt collection summons and complaints. The Supreme Court suggested in JFAC some standards, but we have already published those same standards since 2013. Number seven, the Supreme Court can and is working with MCBA to implement information standards for consumer lawsuits to clarify debt ownership, liability, amount due, so consumers are informed and aware of the debt. And lastly, number eight, we suggest the Supreme Court extended summons life. It's currently only 91 days. We want 182 days to facilitate service of process, avoid unnecessary motions, court costs, and work for the clerks. Before I hand this interview over to my two colleagues, let me bring you up to date on the current status of the Access to Justice project. In November of 2022, the Justice for All Commission issued a report with its quote findings and recommendations to quote modernize Michigan courts. MCBA supports its goal to enhance access to justice for unrepresented parties in consumer debt collection lawsuits. We do not agree with all of its findings or their implications. The reforms suggested in the JFAC report involve improving court procedures. Those are within the province of the Supreme Court. The report did not suggest any changes to Michigan laws regarding judgment enforcement or garnishment. However, the Pew Charitable Trust, which financed the JFAC project, is now going beyond JFAC's suggested procedural reforms. Pew is lobbying for a reduction in creditors' rights, limiting judgment enforcement, and shielding a class of consumers from paying legitimate debts. This goal of Pew jeopardizes Michigan's credit-based economy by limiting bona fide legal debt collection. And Pew's initiatives would actually shrink the availability of credit and make borrowing more expensive for Michigan families and businesses. The Michigan citizens who pay their bills will be financing those debtors who don't pay their debt, because Pew's suggested reductions in legal debt collection will make that class of debtors judgment-proof. I'd like to turn this over to my colleague, Brian Truba, for your comments before we continue. Brian?
Good morning. My name is Brian Truba. I'm on the board of the Michigan Creditors Bar Association, and I'm currently an attorney at the law firm of Mary Jane, Emily, M. Elliott, PC. Just by way of background, after graduating high school, I joined the Marine Corps and then went to college and eventually law school. A couple of years after graduating law school, I worked for the UAW Legal Services in Detroit, where I specialized in debtor defense and filing bankruptcies on behalf of debtors. In fact, that's how I met Mr. Buckles, is defending debts that he was trying to collect. But working there for a few years, I eventually turned to the other side of the coin and represented creditors at Mary Jane M. Elliott PC, my current job. One of the things in the Pew report that I found a little disturbing was the implication of the high default rate that creditors aren't being notified. Having represented creditors, I know some of the reasons why the creditors weren't being notified, having represented them. And there's a variety of reasons why debtors allow default judgments to be entered against them. One of them is they realize they owe the money. They have religious convictions, just the general stress of a lawsuit, the embarrassment of being sued or owing money. And sometimes there's just a distrust of the courts and the attorneys. More recently, we've noticed an uptick in consumers not responding to lawsuits and not communicating with us because websites online are instructing consumers how to avoid debt by avoiding service. And that's one of these outlier lawsuits that they're looking to avoid communication, which is not what we're trying to do.
Thank you, Brian. Jason Sims, could you comment a little bit on that federal court finding in New York?
Sure. Hello, my name is Jason Sims. I'm the Vice President of the Michigan Creditors Bar Association and an attorney here at Buckles & Buckles. Been working on the creditor side of collection work as an attorney for 20 plus years. Mike made reference to, and I'm just going to give some quotes in support to, well, just the important aspects to our line of business, to the overall economy. Research from the Federal Reserve Bank of New York has found, and I'm quoting, consistent evidence that restricting collection activities leads to a decrease in access to credit and a deterioration in indicators of financial health, unquote. Restricting debt collection practices can lead to a decrease in the overall supply of credit, since creditors will be less willing to lend. The report specifically illustrated that auto originations can be significantly reduced following a tightening in state-level collection legislation. That's loan origination at the auto level. That's the amount of dollars that are allowed to be borrowed for an auto loan. Those are important aspects to us here in Michigan, the hub of the auto industry. This same report found that the negative impacts of increased restrictions on debt collection at the state level had a greater negative impact on borrowers with low credit scores. Specifically, and I'll quote again from the report, increasing the restrictiveness of debt collection legislation leads to an increase in the likelihood that an individual has any delinquent balances by 1.8 to 2.3 percentage points for individuals in the lowest credit score categories. So these restrictions to collection can actually lead to more delinquent card balances, and it has an effect on those with the lower credit scores.
Thank you, Jason. John, anything else or questions?
Thanks, Mike. Ben and Lisa, if you're still on and you have any questions for Mike, Jason, or Brian, please go ahead now.
I do have one question.
All right, go ahead, Lisa.
I'm Lisa with MERS News in Lansing. You mentioned a statewide e-file system. Is that possible in Michigan, considering each of our courts, our county courts have different programs that they use? We
Well-
have like one system.
Well, that's something that was brought up years ago, Lisa. E-filing was actually started in 2006 in some courts, and they did have different systems, about 6 different ones. So we proposed, the Creditors Bar proposed, the Supreme Court is we have one statewide system, like they have in our sister states, Wisconsin, Indiana, Illinois, and so forth. The funding, which our clients actually pay a e-filing fee every time we file a suit, was designed to provide funding not only to create buy the hardware and design the software for the system to be used, but also to help fund the courts so that they were on one unified, what they call a case management system. So why they have not used that money and why they have not been able to finance and create that system so there's one common system for all the courts is a question that I think the Supreme Court needs to answer. They've had 7 years of collecting fees, over $50 million. They should have something in place, but they only have it in 10 courts.
Okay, if I may, I have another question.
Sure.
Is there a way to quantify this problem? For example, there's X number on average of consumers who are in debt, and the debt averages X number of dollars a year. Is there any way to quantify it?
I have to get back to you on that. I'm not quite sure I fully understand the question.
Like, are you looking for an average debt?
Yeah, like
Oh,
right. I'm looking
okay.
like a picture to quantify the problem. Does that make sense?
Well, are you asking me what is the average dollar amount of a consumer debt that's filed in Michigan?
Yes.
Well, I will tell you this. Michigan has approximately 93 district courts, which have a jurisdiction of $25,000 or less. Any lawsuit over 25 grand goes to the circuit courts. So in those 93 or so district courts, most of the cases filed in consumer debt collection litigation are filed in those courts. Most of the debt is under $25,000.
Okay, but I'm sorry, I'm not articulating it appropriately. I'm trying to get a picture of what it looks like, what the caseload looks like, and how big the problem is.
Again, that's something we can get back to you on.
Okay.
I'm not sure the Justice for All Commission actually quantified the total number of cases. That they have some figures, they have some calculations, but I don't think they came up with a number. What their comment was that there's, other than traffic tickets, I think in the district court, the most cases that they have to deal with are debt collection cases. And that's no surprise. It's kind of the people's court. And that's why we want it modernized, because clerks are having to deal with paper documents that come in, paper checks, mailing stuff through the snail mail back and forth. Whereas courts like Wisconsin that our firm deals with, it's all electronic. You push a button and file an electronic document and so forth. So I hope that could help you. If you look at the JFAC report, there might be some figures there that help you.
Yeah, and Lisa, there's a few stats I can get you on the number of cases that they claimed were going through the district court. So I'll get with you right after this and send you an email.
Okay, that would be excellent, because I think the last thing I saw, it said something like, I want to say like 50 or 60% of the cases that were filed were debt buyers. And I'm just trying to get that type of picture. So thank you, John. And I will shut up now in case Ben has any questions. Thank you.
All right, Ben,
Hey.
Lisa, put you on the mark here.
Yeah, no, I actually had a similar question to Lisa, the second question she had. So if you can send me that info as well, that would be really helpful.
All right, sounds good. We assume that the Justice for All Commission continues to put out more reports, Ben. I think you just wrote about the most recent 2022 summary they put out. And it's important to just note that there's at least 2 different ways they can pursue the changes that they're talking about, and they could adopt the changes that the association proposed today. Both administratively, a lot of these things can be done internally, but we won't be surprised if there's legislation as well. We haven't seen any yet, but we're keeping a close eye on that.
John, that brings up one last question. So these recommendations from you all have been released today. Have you presented this to the commission or the Supreme Court? Have you gotten any kind of reaction from them about, them including these recommendations also along with it? I'm just wondering what their response was to this.
Thank you, Ben. I emailed our plan to them this morning at 9 o'clock. I think they need to digest it and get back to us. I will tell you that the Creditors Bar has gone back and forth with them, trying to get e-filing done and encouraged, nudging it along as best we could with what we're doing. But we look forward to them responding, and we're anxious to have them respond in open communication and try to implement some of these procedures.
Yeah, that's right. Because if you review the debt collection report that JFA put out last September, which instigated the beginning of this plan, their focus, along with Pew's focus, not only in Michigan, but Pew's operating in many states. Mike is an expert on all the work they're doing in Arizona and Oregon and other places. It's under the auspices of increasing access to the court system, but they focus in particular on debt cases. They go right away to the very end worst result, which is garnishment. And garnishment of wages or assets only occur if there's a default judgment. And a default judgment only occurs if people refuse to participate in the process, because the professionals here on this call and the association, they're not looking for garnishment. They're looking for communication so they can come up with a payment plan or a settlement. There's a way to finish all that without having to have a default judgment on your record and without having to be garnished. The focus of Pew, which is paying for and driving so much of the Justice for All Commission, doesn't even seem to touch on that. And I think that's why the Michigan Creditors Bar Association felt obligated to put this plan out into the public, because they're just not seeing the move in that direction.
Excuse me, this is Lisa again. I had a couple of follow-up questions in reference to what John had said. You mentioned that you believe legislation might be an option. What type of legislation do you expect or would you support? And secondly, what are the next steps after all this? You, for example, you've indicated your suggestions. So what's the next steps after that? Thank you.
Right. As far as the expected legislation, what we do know is that Pew has introduced legislation just recently in the state of Oregon. And the legislation that you're introducing would substantially reduce, would limit bona fide legal debt collection. It would shield, it would stop any garnishment against a person who makes $50,000 or less. It would shield over $12,000 in the bank account. And it would increase exemptions for protection for homes and autos that might be seized and sold to collect debt. Let me just touch on the last 2 points. First of all, Michigan does not allow seizures of homes to collect debt. The judgment lien law that was passed in 2004 by a bipartisan legislature and by a Democratic governor allows us to take judgment liens on property to enforce their judgment, but not to seize or sell that property ever. It just allows us to be paid when the debtor sells or refinances their property. And that is a unique protection Michigan has that none of the other sister states have that. But Pew will probably introduce legislation similar to Oregon's to create this class of consumers who would be judgment proof. And therein lies the point that Jason made, that if you prohibit the debt collection for legitimate debts against people who could pay, you're going to increase the cost of credit and you're going to decrease the availability of credit. With regard to your second question of what's our next step? Well, if any such legislation like that was introduced, we would then oppose it and try to work out some solution, certainly educate the legislators of what we've just told you folks now, of how that type of legislation actually is detrimental to the credit-based economy.
Right, and Mike, and as you've said, the points in the MCBA plan essentially could all be done without legislation. Those are steps they could take now,
Right,
or at least
right.
announce that they're getting into place, like the technology, so we avoid default judgments and garnishments in the first place.
Right, but the issue is not garnishing people who can't pay. The issue is trying to get consumers to respond to lawsuits and communicate. I will tell you that when we do garnish people, their bank account or their wages, most often what happens is they contact us and we work out a payment agreement, or we settle the case, we get a lump sum payment. That's what happens most of the time. And if that would happen on the front end, when we send a letter or when they were served, there'd be a lot less consternation, a lot less court costs. People won't be dug in. Everybody be more likely to resolve it and move on and so forth.
And if I heard correctly, there is no such pending legislation in Michigan as of today, correct?
It's correct. You are correct. Be aware that Pew Charitable Trust has retained 3 major lobbying firms in Lansing, and they've registered 2 lobbyists. Those 2 individuals are the same people who were on the Justice for All Commission dealing with this report. Those people were working with our members, with members of the judiciary and the administration to come out with this JFAC report. But the JFAC report did not include any recommendation to limit garnishment. So after that report came out, we know that Pew is now registered lobbyists and hired lobbying firms. So we expect legislation to come out similar to what they've done in Oregon.
Okay, and do you know who those individuals are, those names?
I do. I can give those to John. He can get back to you. Those
Thank you so much.
The 2 people that registered as lobbyists. Yes, I do have their names. Not off the top of my head, but I have them.
Thank you. I appreciate that. And I
You're welcome.
apologize, but I need to sign out because I have an appointment I'm going to be late for. But thank you so much for the information, gentlemen.
Yeah,
Sure.
thank you, Lisa.
Thank you,
Very
Lisa.
well. Thank you.
Anything else from you, Ben?
No, I think I'm good. The only other question I might have, but it's, it's a little, far out at this point because you guys haven't seen any legislation from Pew and you haven't engaged in that process with the legislature yet. But I'm wondering, if Pew does come to Michigan and introduce such legislation, how do you think that the new Democratic legislature will be receptive to that? You think that they'll be more receptive to what Pew is putting forward, or what you guys are positing as well?
Well, keep in mind that the legislature represents all Michigan residents, and all Michigan residents benefit from credit. It's a credit-based economy. I think the more they know and understand that debt collection, bona fide legal debt collection, helps the economy, helps credit, makes it better for people to be able to get credit and expand credit, I think they will listen to what we have to say, and we will present our points in a polite and professional manner.
Thanks, gentlemen. That's about all I have. Thank you so much.
Thank you, Ben.
All right, thank you, Ben. Have a good one. All right, well, with that, we are all set and we are going to sign off. Have a good day. Good day, everybody.
Thanks,
Thank
John.
you.
Bye.